And welcome to another episode of PLA with myself, Nick, and Bruno. We've got two questions today, and we'll take the first one with Nick and then the second one with Bruno. Nick, the first question goes as follows. We have an occupier who never paid a deposit or any rent. He found the keys to the property that he was viewing. The lease agreement was then signed, but no monies were paid. The lease states that only if a deposit is paid, the lease becomes valid. Now, do we need to commence an eviction process to get him out of the property, or is this a case of trespassing?
Perfect. So it's an interesting question. I've got some concerns about how the tenant found keys to the property in the circumstances when a lease agreement was signed. But putting that aside for the minute, with regards to this question, so we need to be careful. There's obviously in law, we do have laws relating to trespassing. It is a criminal offense, and you can have police remove people who are trespassing. But what we normally do when it comes to trespassing cases is it's really a question of time. Okay. If someone is trespassing on a particular premises, what's fundamental from my client's perspective when they come to me is you need to firstly know how long has the person been on this particular premises. Okay. If a person is using a property as a residence, temporary or permanently, this is what the legislation says, you are going to have to seek an eviction application. Okay, you cannot just approach the police and say to someone that they're trespassing if they've been staying there for a long period of time. So really, it's a difficult thing to do, but trespassing is something that you need to move on as quickly as is possible. We don't have in this question how long the person has been in occupation of the premises, but I would say there are indications that this isn't really a case of someone having trespassed on the premises. There seems to be some sort of indication that they were going to rent the property and they haven't fulfilled the obligations of the lease agreement that was signed. Now, the point that they make, there is a clause in terms of the lease agreement that does say the lease is not going to come into place until it is signed by the tenants in the circumstances, and that's a solid clause that you can include in terms of the lease agreement. Notwithstanding, remember, we don't just bring eviction applications in terms of people that have lease agreements in respect of premises. Okay, if you want to eject an unlawful occupier that never had a lease agreement, you still have to approach the court to do a proper eviction in the circumstances, and where you've cancelled the lease agreement for whatever reason, or terminated the lease agreement for whatever reason, you still have to approach a court to do an ejectment. So I understand the sentiment that the person has said, well, if the lease didn't come into place, that simply makes the person who's in occupation of the premises an unlawful occupier like every other circumstance. And in those circumstances, you're going to have to bring an eviction application. It's never as simple as you can simply go to the police and tell them, well, this person's unlawful, occupying unlawfully. You're going to have to do an eviction in the circumstances, and we get this from our legislation. Our legislation protects, the rights of even temporary occupiers of a particular premises. You cannot simply have them chucked out on the basis that it's trespassing in the circumstances. So, unfortunately, my answer is you do have to go through the eviction process at this stage.
Tell me, Nick, in your opinion, when does, I know there's no proper answer for this, but maybe just for the sake of it, when does the trespassing turn into intention to permanently reside? Or
it's a good question. I know why you ask, because it's one of those things that how long is a piece of string? Yeah. It's one of those things that how long is a piece of string? It's got to be assessed on the circumstances of the case. So the reason I give my answer the way I did, and I'm not sure, maybe you disagree with me, Bruno, is the fact that there was some sort of negotiation beforehand, some signature of a document, and then a non-performance in terms of that document does not allude to me that there's been some form of trespassing. And as I pointed out at the start of this question, I have a little question mark around how the keys got got into the hands of this particular person. It might be the case that they found keys. Hell, maybe they snagged them off the table and didn't tell the agent at the time. But I think there's a chance that they were handed over to the tenant, or to the occupant rather, at some point, which doesn't lead me to believe that there's some unlawful trespassing. If the circumstances of the case were different, let's say that this person was in the property and they had gained access of the property. There was no lease negotiation, no showing the person occupant the property, and they had broken in through the front door, and the front door was now sitting ajar on the side. I think the facts of your case might be a bit different. Okay, provided you hadn't let them stay there now and given them some, not actually acted on it. Then you've got a very good case to say to the police, listen, someone is trespassing. They have broken into the house, and there's a myriad of other things that might be criminal offences. In those circumstances, absolutely. But I have a difficulty with this case because, for all intents and purposes, the actions up to the point of the tenant getting occupation of the premises seem to suggest to me that they intended to enter into a lease agreement. And the tenant is not performing in terms of the lease agreement, and there is a good argument, as the writer points out, that the lease actually never came into place at all. Absolutely perfect. Does that make it trespassing? I don't think so in this particular case.
Sure. Yeah. Okay. So thank you very much, gentlemen, for that one.